Senate Bill 2472, eminent domain. To get real simplified, this bill is simply a codification of the constitutional provision of eminent domain that was passed by the voters. And this bill is coming forward as a precautionary measure for the event should the procedure by which it got adopted remains, I guess, well, it's been ruled unconstitutional. There's some questions out there. So what we're trying to do is codify that. That's really what it does. We do have a proposed amendment to that. You have it before you. Oh, I'm sorry. Is that right? Okay. So, well, if they want. So with that, I'm going to turn it over to Senator Hobson for an amendment, for the simple amendment.
Thank you, Mr. Chairman. And you have a copy of the amendment.
He does.
I ask council to prepare a copy of it. Let me
Senator, if I may say that, this is similar to a floor amendment. It's really a bunch of hands and punctuation. The words are just so when you see it, just know that's what you're looking at.
Yeah, thank you, Mr. Chairman. This puts semicolons after certain words, and if you look at the bill, the only very minor, and this is a clarification change. I've talked to attorneys about this, trying to make sure that we do what we think we're trying to do, and as artfully as the proposed constitutional initiative was, just kind of like the medical marijuana initiative, I think those that were supporting that initiative even acknowledged there were some tweaks that could have been made in the language, and I think the tweak is that after the ports, airports, wayports, I can't find my full bill, but after those 4 different ports, it would say only add these words, and access and development incidental thereto, so that you don't have an access issue to the ports or airports, and that the development there is part of the port is also included. That's all that it does. It's just, to me, a clarification that'll make this bill and this language much better. You have questions, Mr. Chairman?
If I may, just looking at the line, it's at line 17, 18, 19 that simply adds in those words. So with that, I'll open it up to any questions. All right, no questions. Move the motion. Senator DeBar, is this on the amendment?
Yeah, I recognize to speak against the amendment.
Okay. All right, do we have questions on the amendment? All right. Let Senator DeBar wants to speak against the amendment, and we'll have Senator Hobson.
Thank you, Mr. Chairman. This is a bill that I've dealt with really since last fall with Farm Bureau. We've worked this. This is exactly the language that was passed in the referendum 10 years ago. It's the exact wording. To change it now, I think would basically tell the people that they didn't know what they were doing. And even though it is small changes, it is different from what was passed. I've heard no complaints, no issues with the eminent domain law, with this constitutional amendment since the referendum was passed. And it passed with 70%. I think I was looking at the vote. I think only one county was below 50%, and that was I think it was 49.56, so it was really 50%. So to change it now, I think would go against what the people wanted, what they asked for, what they got, and so I would oppose the amendment.
Anybody speak on favor of the amendment? I'll let anybody. Senator Hobson. Yeah.
Thank you, Mr. Chairman. I think if you look at the proposed amendment, it is not any poison pill, and it's not doing anything other than clarifying what I think is Senator Barr's point that the people voted on this. I think, as I said a while ago, I think when this was drafted, I think the people who were, I'm not sure who drafted this, but I think they did a very good job drafting it. I wouldn't say it's perfect, because I think the language that you see here, particularly the access and development incident there too, really important. If you live, I'm gonna say this, if you live in a county like I do, where you've got a waterway that you need to access for your port, good luck ever developing the water. I think that's not what intended, but I think if you look at the language in the bill, you may get to the point. I think the simple point is when you develop a port in Pascagoula, the Tenn-Tom area, or the Mississippi River, or any place in our state, if you develop an airport, you develop it, and that's the center of the commerce. You co-locate, you lease space to Delta and American Airlines, you lease space to Avis and Hertz, you lease space to General Aviation. You develop a port in your community. You lease space, for instance, in my port in Vicksburg, the port's developed, but they lease space to Ergon and the Corps of Engineers and Big River Shipbuilders. When you lease space in Pascagoula, you lease space where you sell space to Ingalls and Chevron and all these companies. If you're contending on this, there would be no reason to ever develop an airport or a port if you don't follow this logic. And all this is saying, this is not something bad. This is simply saying that when you develop a port, you're developing it to co-locate businesses on that port or at that airport. So I think this is just clarification of what I think people would expect for their communities. They're developing a port or airport. I happen to live in a city where the port's a big deal. It's a huge deal. And I think every piece of property that exists on the port in Vicksburg is either sold or leased to a private entity, a company like Ergon. It's one of the huge companies here in Mississippi. If you're telling me that Ergon can't locate on that port, if we want to expand our port in Vicksburg, you may want to expand your port in Pascagoula or in Avery or Tupelo or West Point or wherever it is. You may want to expand it. I'm afraid you won't. How could you ever expand it? Because there's no need to expand it. You can't put numbers there. This is simply, I think, a clarification. It's not doing any harm to the bill. It's just explaining what you do when you develop those 4 sites: a port, an airport, a public harbor, and a wakeport. I don't know which wakeport you have, but the first 3 for sure. I think this is clarification.
All right, so we're on the amendment. All in favor of the amendment, say aye.
Aye.
All opposed, say no. The ayes have it. All right, we'll have a roll call. We'll do a division. Okay, all in favor of the amendment, raise your hand. Secretary, Mr. McCon. All opposed, raise your hand. Amendment carries. All right, we're on the bill as amended, committee substitute. Motion is title sufficient, do pass committee substitute. Senator England.
I have a,
Before we go to the vote.
yeah, I had a question. I was gonna ask if we put a reverse repealer in it. To continue, this is just the first I've heard of it, and I think that Senator Hobson raised some good points, and I would just like a chance to look at this further, to talk to some folks about this amendment.
You certainly have the right to make an amendment, but I think it's, it's been stated here what the purpose is. I don't know that that's the only change that has been discussed or made. And in fact, it's not even a change, it's a clarification, as Senator Hobson said, Chairman Hobson said.
I'll withdraw my amendment. I may look at it further and do something
And if
on
it
the floor.
passes, it goes to the floor, so.
That's right.
That's right. Okay, so we're on the motion, title sufficient to pass. All in favor, say aye. All opposed, motion carries, title sufficient to pass. Okay. We're gonna go to the top of the docket, to the top of the agenda, sorry. Civil Law Subcommittee Chairman, Mr. McCon. Senate Bill 2321.
This bill is, after work, traffic again. Currently, we have a criminal find that this bill has been tightened up extremely tight to make sure that it doesn't have unintended consequences. The goal is not to go after a gas station where people stop with people driving a car. The goal is to go after someone who knowingly, intentionally, and willfully participated or benefited from human trafficking in some form. The bill will provide a remedy for damages approximately caused by the trafficking, and the person which include compensatory damages will cause reasonable attorney's fees and punitive damages. Ideally, we're just trying to provide these people the ability to file suit if they so find that it's necessary they can. And you'll see this more, honestly, it's gonna be more like a website or somewhere like that that know the intention will benefit. It just provides another tool for combating human trafficking. It provides some rehabilitation, compensation mechanisms. Are there any questions?
All right, any questions on the bill? We have a motion. Motion's title sufficient to pass. All in favor say aye. Aye. All opposed? That carries. All right, I'm gonna skip down to number 5 on the docket. Gosh, I'm sorry, y'all. Number on the agenda under Senator Boyd, Senate Bill 2620. No,
26.
sorry, Senator. All right, any questions? Motion, Senator Blackman.
Thank you, Mr. Chairman. Cannot a court already award attorney's fees in matters? Some we make in our prayer, we'll ask for cost of prosecution, attorney's fees, and any other relief that the court deems proper.
We're on your bill, Senator Thompson. Her question.
The question, sir, Black, I'm sorry,
Yes,
Can
a court, if in its discretion already, if you make a prayer for relief or attorney fees and any other cost, can the court award that?
the attorney's fees will award, allow the senator instances where, parties may be repeated duplicative requests for that type of information. And the party who's a state agency has to seek protective order, protective. All this would do is to allow chance for attorney's fees on a finding that some third party has made.
And if that third party has done that, and the court finds that it's abusive, the court can't award attorney fees when they're repeatedly coming in for the same thing.
Not under the terms of Congress, this is what the change.
My chairman is saying they can.
No, I'm saying they cannot
Okay.
under current law.
Okay.
Not
Okay,
under
thank
current law.
Okay, we were, okay.
Okay? Any other questions? Do I have a motion? It is title sufficient to pass. All in favor say aye.
Aye.
All opposed? Okay. Now Senator Boyd, thank you. Now Senator Boyd, now Senate Bill 2087. And I will note that we're the second committee. This came to us from AET, so I certainly put faith in Senator Polk and his committee. Senator,
Chairman.
question?
Okay, now this is just for state agency. Okay, so when we get to the floor, we're gonna, amend the title to the form that it says here, any public.
Good question. We can certainly do that. Is that okay?
I know that's what it say on the floor.
We can do, yes, we can do that. That's, make a note of that. Okay. Any other questions? Motion? Do pass, committee sub. Title sufficient, do pass, committee sub. All in favor say aye. Aye. All opposed, that carry. Ayes carry. All right, next on the agenda, 7 and 8, I'm gonna call the next two up, in block and explain. So what we have here is, and I will rely on council to a degree, on our landlord tenant act, I forget which federal judge, but it was ruled unconstitutional. Judge Mills. So what you have before you is item number 7, Senate Bill 2461, is the bill to address that that decision to bring our law in line with the Constitution as they set it. And it deals with notice and the property that was taken on that. What you also have before you is number 8, Senate Bill 2626, that first I will note has a reverse repealer in it. What this is Senator Johnson has been working on this, and what has occurred, has occurred is that the decision has brought forward some ideas about doing a comprehensive review of the Landlord Tenant Act. And so that's what that bill is. in 26. That, and I will just note, if you look at, on that one, if you look at, line 189 on the effective date, sections 2 through 7. This act codified new sections of law will repeal the sections of law held unconstitutional by the federal court in Connor v. Alden. And then it goes on to talk about and clean up the Landlord Tenant Act. To the committee, I've talked to Senator Johnson. He's been working hard on it. There is a reverse repealer in it with the idea that this would move forward. And if we can get there, then that would be where we needed to go with this. It also incorporates the changes. And when I say incorporates, it actually addresses the constitutionality from that case. So that's why I have the two bills before you. I do think that in that decision, Judge Mills, I think, gave us till. Thank you. And the committee substitute on Senate Bill 2461 makes it effective upon passage so that we don't have a gap, so that as soon as we do that, the businesses and the landlords and the tenants would all know. So I'm sorry. That should okay, so that amendment is to make it effective upon passage. All in favor say aye. Opposed? Okay, we're back on the bill. We have them in block, so do I have an objection to discussing those in block first of all? Guess not. Okay, question, Senator Turner. I think I'm doing this in committee. I will tell you, I spoke to council on the floor. It would be, you would have to call them up individually. So, and then in terms of making any changes or anything, I think we need one of the two, certainly. So, and this one does have a reverse repealer, 2626. So I guess my point is if we can get there on 2626, that would be the comprehensive review. That answer your question? If your question's in block, if the question's about in block on the floor, if it shouldn't pass, we would do them individually. Well, I don't think they're not merged. They're just brought up together. You can still amend either one, correct? And 2626 has the reverse repealer in it, which makes it go to conference. And I will I will be talking with Chairwoman Cockerham about this as well, because I don't think that there's a House version of this bill, but there are both sides of the issue that led to this decision have been discussing with Senator Johnson on this, and I think we can try to get somewhere. And I personally have been told and heard that there are issues that would like to be addressed in our Landlord Tenant Act. In other words, it's probably due to be updated. So that's what we're trying to do. Any other questions?
I guess I have related to this in block too. So if you want to vote, you got to vote for both. We got to vote for both, or
In committee, yes.
okay. So then I have to vote against both if I don't.
Okay.
Okay. Even though I like one.
Well, so do you? Yeah. Well, then I register that as an objection. So we will go with
Thank you.
to the in block. It was worth a try. So we're on Senate Bill 2461, which is what I call the simple fix to the surgical fix to the decision. Put that way. So any questions on Senate Bill 2461? All right, All in favor, say aye.
Aye.
All opposed? Okay, that one carries. All right, now we're on, Senate Bill 2626. Any questions on that one? Specific questions? Senator Turner. I don't know any specific answer to that. I can speculate, but I won't do that. I don't have an answer to that. Well, and this is why we have a reverse repealer in it. And I certainly have talked to Senator Johnson, and that's something that we can address as it's on the floor.
Sure. Senator Turner Ford, also in, I gotta get the section number, I think it's around 10. Section 11. Line 469 on the bill actually exempts campers from the Landlord-Tenant Act. So this, the landlord, the campgrounds you saw would be codified in a separate chapter. I don't know if this helps you or not with your concerns, but just for your information, Section 65 says that the campground shall be codified in Title 75, Chapter 73, which is just a separate area to deal with hotels and lodgings. It's not within the Landlord-Tenant Act. So what this bill would actually do is say that the Landlord-Tenant Act doesn't apply to campgrounds, and campgrounds are dealt separately. It is a rental, but they're written into the motel and something else provision in Title 75. The lodging house, basically. This bill actually abolishes distress and distraint for personal property for residential tenants. So, meaning that the landlord can't come in and take personal property under that bill. You would have to do a separate action for any personal property, but like a car or an automobile or something that is already set up in statute. But as far as like just furniture, laptops, things of that nature, that's abolished under this bill. For residential tenants, but commercial tenants can still have their property, have a lien put on them. What happens is after the judgment of possession is granted, the tenant is given a certain amount of time, usually, and in this bill it says 7 days unless a different time is found, and they have access to the unit to remove their stuff during that time. If they don't after the 7 days, then the landlord can come and get a warrant of removal. And if they do get the warrant of removal, they still have a 72-hour period after that warrant is executed, that they can come back and get their stuff from the unit. And then after that, the landlord can just throw it away. It doesn't become his property. They do lose it, but they have that 7-day period first, and then 72 hours once the warrant's executed. And then if they just aren't there or aren't around, then the landlord does have the right to put it on the street.
For the benefit of the committee or the committee members in the audience, and I'm summarizing here, but the basis of the suit or the case was taking the tenant's property by the landlord or disposing of the property without proper constitutional protections. So that's why we're here. So, okay, any other questions on that one? Do I have a motion? Motion is House Sufficient New Cast Committee sub. All in favor say aye. All opposed?
No.
ayes have it. All right, we will go to actually, we're gonna not call up number 9. Number 10 was a mistake. That was actually, we've already done that one. So we'll go to item 11. Senator England, Senate Bill 2015.
Yeah, thank you, Mr. Chairman. This is a simple bill that just allows for parents to receive redacted copies of reports from youth court. Currently, the current language is that the attorney must request this. This just adds parent, guardian, or custodian of the child may request it. And I understand from talking to some folks about this, such as Senator Barrett, that a lot of courts are already doing this anyways when the parents request. So this just allows them the option in the code.
All right, any questions? Questions, have a motion?
Title sufficient do pass.
Motion is House sufficient to pass. All in favor, say aye.
Aye.
Motion carries. Thank you, Senator England. We're gonna go back to the first page. And take up Senate Bill number 2465. Senator McCon.
This bill is coming to us unfortunately at the direction of the Supreme Court. Essentially, they've issued a ruling recently regarding a lien and a complaint. You've got a list of defendants that's filed generally when you file a complaint. Generally, I actually just filed one recently in Chancery Court, in which case it says in the code that it's got to be filed simultaneously. Unfortunately, it's almost impossible to make it filed simultaneously. Even whenever they filed my complaint, they turned around and filed the list of defendants right behind it, which was not simultaneously because it was 30 seconds later. The Supreme Court said that we've got to fix that, and that's what this bill does. It provides an option for the lien to be filed anytime within a time period after the complaint is originally filed. It's been changed a little bit in our subcommittee. We went through this pretty good and made it where it's 30 days from the date in which the list of defendants could be filed. Which what that does for most of you know is that it provides the date in which priority would come into play for that. So the judgment will relate back to this list of defendants date. So if I were to file a lawsuit and then turn around and file that list of defendants 15 days later, it's not going to reflect the date that I filed the lawsuit. It would be the date in which the list of defendants is actually executed. You don't have to wait for the judgment. The judgment reflects back to the list of defendants. All that to say, this puts in place 30 days from the date you file the lawsuit, in which you've got to have that list of defendants filed, or else you actually lose your place in line with that list of defendants. I would entertain questions, Mr. Chairman.
Thank you, Senator McCon. Any questions on that?
Title sufficient to pass committee substitute motion.
Title sufficient to pass committee substitute. All in favor, say aye. All opposed? Motion carries. All right, we'll call up Senate Bill 2509. This actually comes back to us from our valiant Vice Chairman in Highways and Transportation. This is and we have Mr. Baker here, but the bottom line is, this is the one dealing with the height of the signs, and there was one change made by the Highways and Transportation Committee, limiting it to, is that on lines 25 and 26? So it's a narrower version, and it only applies going forward, the changes in short. So that's the change that was made. So the changes that they're doing only goes forward. Basically, you're grandfathering in everything that occurred. Is that right? Okay. So thank you. All right, any questions on that? Motion is title sufficient to pass. All in favor say aye. All opposed? Motion carries. Thank you, Senator Branning, for that. Okay. Next, I want to go to, call this the Senator Blackman bill, number 14. This is the one that was tabled subject to call.
Right.
I'm going to call it up. this was, if you recall, there was a discussion between Senator Hobson, and I'm calling it up to see if, with the idea that we continue to pass it. You remember, this was whether somebody that's adopted can receive their birth certificate when they reach 21. Senator Hobson.
Thank you, Mr. Chairman. I thought we had made an amendment that it's in here that if it was sealed, that it would not be, the court ordered it permanently sealed or until such time as the court may otherwise release it, some language to that effect. Maybe we never got to that point, but I think that was the,
We never got to the point.
okay, it was tabled before that.
Senator Boyd?
Mr. Chairman, I'm gonna recommend that we keep this as a table. Do we maybe just take it off the table? Do we maybe just?
Well, actually, did.
Okay,
Yes, I've taken it. It was subject to call the chairman, so I've taken it off the table.
okay. I'm gonna recommend that actually, this, there's some drafting edits that were suggested. I think it deserves further discussion. And I would continue to play this table to let us kind of work through this process.
So it's motion to table, is your motion?
Yes, mission to take.
So the motion before you is motion to table. All in favor, say aye.
Aye.
All opposed? All right, motion carries. That one is tabled. All right, next, go to number 12, Senate Bill 2356. And what you have before you is a proposed committee substitute. This is, and I'm gonna let, find it. In that bill, that's Senator McConn's bill. The committee substitute before you, I'm sorry, Senate Bill 2356.
It's in there, it's a one pager.
Okay, thank you. Thank you very much. So it's one page from the original bill. Multiple sections have been stricken from that. What you have before you is a proposed committee sub that simply states that no offender shall petition to change their name. What we have been receiving have been complaints from various chancery groups, the chancellors and chancery clerks, that this has been a continual issue. So Senator McConn, do you have anything to say on the bill? What did I say? McConn? McMahon. I'm sorry. Senator McMahon. Sorry. I'm sorry, it's 3:30.
Bill's one thing, Bill, that effectively says chancery judges brought to my attention in the last 2 years, there's an issue that offenders are petitioning the courts to change their name. So, while incarcerated, so what this does, it just says that they don't have these standards before chancery unless one of the exceptions applies. The exception is that a district attorney can file a petition on behalf of the offender. Line 25, a sheriff Line 28 says the commissioner of Mississippi Department of Corrections or his designated to file. And then also put in a religious exemption in there. Line 31 says the Department of Corrections chaplain in case the lady got married, change her name. She would have to do some methods. Like I said, it's 2 pages. It does exactly what it says it is do.
All right, we're on the bill. Committee sub, any questions? Senator Hobson.
Thank you, Chairman. Senator McMahon, how did you come up with the Real You Act 2022?
Well, that's so one of the changes brought to my attention, like someone's incarcerated for 5 years. They've actually petitioned to change their name 4 times in 5 years. Change their name.
I know what the intent is. I'm just curious how, where we come up with that title.
Well, it came up because it was causing confusion in the court system. People are constantly changing their names.
Identity, I'm fine with that. I did try to change my name a few times. Interesting name.
Any other questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. Committee all again, say no. Committee substitute passes, title sufficient, do pass. Carries. All right, we have one, I'm sorry, two other things. Before you, it's not on the agenda, Senate Bill 2616. This passed out of subcommittee, and it's lines 105 to 108 is, in short, taking out gambling winnings for to pay child support. That passed out of subcommittee, and that's the bill. Lines 105 to 108 are the optimal, or the changes to the law. Have any questions? Yes. Yes, winnings are subject to. If you look at 107, 108, the parent's winnings should be applied to the parent's outstanding child support obligations. Senator Hobson.
Thank you, Mr. Chairman. While I understand the intent, I am concerned about the application of this. How would the gaming establishments know who's at the slot machine to be able to get their winnings, or who's at the card table to get their winnings?
So you raise a good question. That has been brought forward and mentioned. That the question is, for example, if you win $700 at a slot machine, how are they going to know that and do that? I think that is a concern of the gaming commission, of the gaming industry.
I think it's going to be really hard, if not impossible, to apply, certainly fairly. And just, if I may speak on it, my concerns for a moment rather than ask the question. Sure. I can see a situation where there's probably a handful, they're probably each gaming establishment, I would imagine, would have certain people they know are regulars and people they know are coming in. One, how are they going to know those people are some kind of child support order? And two is there are probably so many people that don't come in. I mean, they come in that they don't have any. They just, it's a random person, you or I or Joe, down the street that decides to go there, and I just think it's going to be almost an impossible task for them and for the gaming commission to try to enforce this.
Well, I will note in lines 31 and 32, it states the commission shall coordinate with DHS to do the rules and regulations.
Have we got any information, you had a chance to speak with the gaming commission about this and how they go through that process and what it's going to cost, what they're going to ask us for on the budget to try to implement?
I have not. I've spoken to their lobbyists, but I've not had detailed conversations with the gaming commission or with the gaming industry. I'm sorry.
Motion from
Okay, motion. Senator Boyd.
Can we, this is an issue that was brought up by the peer report, if I remember correctly. There's a peer report on child support obligations. May I make a motion that we put a reverse review on it here and kind of work through and see these questions?
Yes, it was a peer report that came forward. So that's your motion on the table.
Is to add a reverse reviewer.
Okay, to add a reverse review. All right. So we have a motion to add a reverse repealer. All in favor say aye. Aye. All opposed? Motion carries. Okay. So now we're on that. You had a motion, Senator Hobson?
I'll rest.
So we're on the bill, the committee substitute. Have a motion on that.
Title sufficient do pass committee sub.
Title sufficient do pass. All in favor say aye. Aye. All opposed? That carries. Okay. Last one on your agenda is for discussion, Senate Bill 2614. I'm not calling that up for a vote, but it's on there for discussion. This passed out of subcommittee, and many of you have discussed this issue with the representatives. The bottom line is it's a bill to help streamline the minor settlement. I will tell, if you haven't already heard, the chancellors, at least a number of them, have come out opposed to it. I will say this, I was in the subcommittee that was there, that when we passed this out, and this has been about, in my opinion, about streamlining and making the court system better for the people. We did receive a letter from the chancellors, and I think it's a good letter, that states about the people that are in their courts. But what I was also told was that that's the first time that the chancellors raised the issue, even though they were approached. I don't know whether that's the case, but it seems to me like this issue could have been addressed before it made it through subcommittee. And I know efforts were made to make those discussions. What is clear, even in the letter, I wish I don't have it in front of me, but even in the letter, there was a quote from the chancellors that said they would love to not have to deal with minor settlements, but that's what they have to do. There is an issue with minor settlements in this state. And I think this bill, this vehicle, was a way to get there. But certainly the chancellors also brought up a reason for example, of the people that they see, the children, and I think in the letter they cited an example of how do they know what they're getting? Are they getting the proper representation? So we're not going to call it up for a vote, but I do have a copy of the letter if you would like to see it. I know Senator Branning has it. I think it's an issue that needs to be addressed. I've talked with the insurance representatives. I think they're willing to come to the table. Well, I know they're willing to come to the table and talk about it. But at the end of the day, it's about what's best for minors, but it's also about making the system better, because I think if you practice, you clearly know that there's issues with the minor settlement. So that's my discussion. If anybody would like to say anything, I certainly will open it up to the committee. Senator Boyd, you deal with anything? No. Okay. Anybody? I guess it was my discussion. So, yeah, Senator McConnell.
I would like to ask, there's been some discussion as to right for this on study committee, and maybe everybody come to the table. Is that something you're considering, or what do you think?
It is being considered. I've got to talk to our counterpart in the House, Representative Cockerham, to see where they are on it, and we're talking on that. So it certainly is on the table to do that. So with that, I want to say thank you to the subcommittee chairs. I think it's been very good. I appreciate your work. And with that, we are going to have a motion to rise and report. Rise and report. All in favor, say aye. Rise and report.